Good afternoon, everybody. Hello, class. Good afternoon.
Good afternoon, sir. We can hear
Good
you.
afternoon, sir.
Good. Thank you very much. I know today is Saturday when every one of us should be enjoying his weekend, but due to this extra class, we all have to be here. Thank you very much. For those of you who have time to join, thank you very much for joining. We'll try as much as possible to do a recap of what I have taught you in the last week, in the last 2 weeks. I recall that I introduced you to the concept of mortgage, which is a commercial transaction in which property is used as a loan. Property is used as a security for a loan, and that there are various rules governing it. I taught you how to the creation of mortgages, be it legal, be it equitable, both in the PCL states, in Lagos states, and other states where property and conveyancing is applicable, and in non-common law states. Today, I also look at the last lecture, we also look at mortgages under the Land Use Act, the effect of Land Use Act on mortgages, both on legal and equitable. Questions like whose duty is it to obtain consent? Does equitable mortgage require consent? And the practicality of it, the stage at which consent is to be obtained, effect of not obtaining governor's consent, and whether a mortgagor who fails to obtain the consent of the governor can be allowed to profit from his inactions. All sort of cases on Ojubagbe Light Industry, Savannah Bank, and Agilo, they were well discussed. Another mortgage, which is also important for us to take a look at, is mortgage by estoppel. And this one will arise when the mortgage deed is executed, the mortgagor has no interest in the land. And what
That was section 254, sir. If I'm correct.
254 where?
Yeah,
Hello? Giwa? Hello?
Hello, sir. No, I was talking to someone, sir.
Can you unmute your this thing? Can everybody unmute their this thing so that you don't disturb the flow of the lecture? I said we'll start today with mortgage by estoppel. A mortgage by estoppel will arise when the mortgagor has no estate at all, as at the time of creating the legal mortgage. The mortgagor subsequently acquire that interest. At common law, a grantor may not dispute the validity of his own grant. Thus, if the grantor subsequently acquires the land, he fixes the title. Let me give you an example. An equitable mortgage, a beneficiary under an estate who has not been given the vesting title, if he uses the title, he uses the mortgage, equitable interest. If he mortgages his equitable interest, that is a subsisting interest. But assuming he creates a legal mortgage and an equitable mortgage, and subsequently a vesting certificate is issued to him, then by getting that vesting certificate and creating a legal mortgage, if the banker wants to take it, he has fed the title. That is mortgage by estoppel. If you read the case of First National Bank against Thompson, which is 1996, One England Law Report, this is a case in which a vendor transferred land to a purchaser who had already executed the legal charge in favor of the bank. The purchaser was duly registered as proprietor, but then objected to the registration of the bank's charge. It was held that the purchaser was bound by the mortgage by estoppel from the moment the mortgage deed was executed and so could not in any event object to the registration of the bank charges. I want you to take a look at that case. It's a new concept, mortgage by estoppel. You are stopped from denying the existence of a transaction. The other method of creating an interest in mortgage is by equitable mortgage. Now, equitable mortgage as opposed to legal mortgage, they are mostly informal. Equity follows the intent rather than the form. Equity is more interested in the intention of the parties. So if there is anything on the part of Court of Equity or Chancery to be able to see that what is the relationship between these people, what do they want to create? If it is a security that they wanted to create, but they do not comply with the legal formality, equity regards as done that which ought to be done and impresses on that character the species of the transaction. So today, and in the eyes of law, it is possible to create an equitable mortgage. When an equitable mortgagee mortgages is equity of redemption. And this you will find in all the states except the PCL states. In common law states, as I taught you before, upon the creation of a legal estate, only one legal estate can be created. Subsequent estates are equitable. Mortgages are equitable because only one person, which you call Queen's mortgagee, only one mortgage is creatable. And once you have created a legal mortgage, all other mortgages you are creating will be equitable because you have transferred the totality of your interest by creating a legal mortgage in favor of the first, the legal mortgagee. So what the mortgagor has is equity of redemption, which is also a bundle of rights. So once a mortgagor that has created a legal mortgage creates subsequent mortgage or mortgages as equity of redemption, then those mortgages are regarded in the eyes of equity as equitable mortgage. But you cannot create equitable mortgage in PCL state because you are allowed to create a multiple legal estate by demise, which is like creating a lease or a sublease depending on what you have. The second method of creating equitable mortgage is when a beneficiary of interest in land creates a mortgage on the land, which was an example that I've given to you earlier. A beneficiary under a will, if he mortgages his interest in land given to him under a will, in that case, he has only created an equitable mortgage because the legal estate in that property is vested in the administrators or the executors of the will. So until the property is vested in him as the legal owner, the legal ownership of that property is vested in the trustee while he is just a beneficiary. The interest he has, which is in that property, is equitable. And so he can also use his equitable interest to raise money. That is also possible. This is applicable in all the states in Nigeria, even in PCL state. A beneficiary under a trust or a beneficiary under a trust or a beneficiary under a will has only an equitable title, and so it can only create an equitable interest. Now, another method of creating equitable mortgage is where there's an agreement to create a legal mortgage. Agreement to create a legal mortgage is different from a legal mortgage. It is just two parties entering into a formal writing contract that I am going to create a legal mortgage for you in future. It can be by a company, it can be accompanied by deposit of title. That is, the mortgagor can walk into the bank or financial institution asking them that, please give me a loan of 1 million naira. Take my title document, my certificate of occupancy. I will execute a legal deed for you in future, memorandum in writing that I will do that one. In the eyes of the law, that is served as an equitable mortgage. You have not fulfilled the legal form. If you see the case of Ogundeani and Naraba, 1978 6-7 Supreme Court, the court, because it's a contract, you can bring an action for specific performance, requiring that mortgagor to come and execute a legal contract for you, a legal mortgage for you. That is acceptable in the eyes of the law. And so, any agreement to create a legal mortgage is as good as creating it's an equitable mortgage, but it has a special advantage because you can compel the mortgagor to perform his own side of his contract through specific performance, and that has always been accepted in law. And you will see the last method of creating equitable mortgage is by deposit of title deed. Very simple process. The mortgagor walks into the bank or a financial institution, asks the bank to give him money, and just deposit it, whether with a memorandum or without any memorandum. Once the bank has in possession your mortgage title, yes, in the eyes of the law, you have created an equitable mortgage. And because that is also applicable, is recognized all over the states in Nigeria, except Lagos. Under the Lagos State Law, Section 18, subsection 2, the practice of creating equitable title by mere deposit of title deed is no longer applicable. It must be evidenced with an agreement to create a legal mortgage. So what is applicable in Lagos State is that if you want to create an equitable mortgage, not by way of deposit, but you can do so by agreement to create a legal mortgage. Do you have any question for me on creation of equitable mortgages before I move on? Class, are you there?
Yes, sir.
Yes, sir, I hear.
July fire on?
Yes, sir, I can go on.
Okay.
But we have a question.
Yeah, go ahead.
What's the section of the law that is stated in Lagos State? I didn't get that. Sorry.
It is section 18, subsection 2 of the mortgage law of Lagos State. The mortgage law of Lagos State, section 18, subsection 2, provides that it is no longer possible to create equitable mortgage by mere deposit of title. Any equitable mortgage that is acceptable must be evidenced by a memorandum of deposit. Is it clear?
Yes, sir. Thank you.
Okay, we go. Now, let us now move towards the rights of the mortgagor. Now, this is one of the areas where equity plays a pivotal role in the development of the law of mortgages. And it is so because in the eyes of common law protects the mortgagee in that the common law lawyers or judges saw mortgagors as necessitous person who can say anything and can take money. So once you collect money and you are unable to pay, the attitude of common law is that an agreement is an agreement, just like Wike's own. When are you going to pay? 6 months. Have you paid? No. What is left? Do you have any money to pay now? No. Your interest is foreclosed. You can know that is the end. Once the day of redemption, the legal right day of redemption has matured, and you are in default of it, what do you find out? The common law lawyer will foreclose your interest. They will tell the person to go and sell. They don't even need to go to court because you have already executed the conveyance. What they will just tell you is that don't bother to come again. You have already transferred this thing to me. I've registered my interest, and your interest is hereby foreclosed. And so, for so many years, many people were cleverly and unwittingly deprived of their properties. And because of that, the necessitous debtors, they have to cry to the chancery, who came up with so many principles to ensure that the whole essence of security, the whole essence of mortgage as a security is recognized and respected. That's what they'll say. A mortgage is never a sale, but an instrument of security in the hands of the creditor in satisfaction of payment of the loan. So around that principle, so many rules comes into play. If you are somebody who knows Bible very well, if you read the book of Nehemiah chapter 5, verse 5, you even see that the wickedness of the mortgagees is started from the biblical days. It's time immemorial. If you read Nehemiah 5, verse 5, the mortgagors were mortgaging the Israelites. They were mortgaging their properties to lenders. And what did you find out there? Our people, the lenders, they were taking over their properties, taking over their children. They don't care what happened to them as far as they are concerned. Once you don't pay at that day, they will just take over your property, and then they go away with it. And that has always been the lot of the borrower before equity came into play. I say, no, once a mortgage is a mortgage is not, you see what they said. They just wanted you to know. So you have this at the back. Although we are, Nehemiah 5 chapter 5 says, although we are of the same flesh and blood as our fellow Jews, and though our children are as good as theirs, yet we have to subject our sons and daughters to slavery. Some of our daughters have already been enslaved, but we are powerless because our field and vineyards belongs to others. That was even the Jews to themselves. So the situation of the Israelites who are forced to sell their children into slavery due to debt and famine. They were experiencing same hardship as their fellow Israelites, yet they were subjected to forced servitude with no power to redeem their children or even to redeem their property. That is to show you the wickedness of man to another. And this you will find more when you now realize or understand the rights of the mortgagor. The first right that a mortgagor has is the right to redeem the mortgage property, otherwise called the equity of redemption. There is a difference between the legal date of redemption and the equity of redemption. One, he has the right to redeem the property, and he also has the second right he has is the right to remain in possession of the property, to grant lease of it or to accept surrender of lease. Let us take the first one, which is the right of redemption. The first and the most fundamental characteristics of a mortgage is that once a mortgage is always a mortgage. In other words, a mortgage is a security transaction, it's never a sale. It is subject to the right of the mortgagor to redeem the property. That's why they put the clause, subject to Caesar on redemption. That is, you will release this property to me once I redeem. What is redemption? Redemption is your right to pay your debts, your principal, as well as your interest. Once you pay your interest and your principal, the mortgagee should give you back your property. It's not a sale. So, because equity treat mortgage as a security, even in the eyes of the law, it's still a security. You own immediately you have created a legal mortgage. You have what in the eyes of equity of redemption, which is a bundle of rights, which you can use to create subsequent interest. But you also have what we call the legal right to redeem. Once that day has come, you have the right to redeem. Once you don't redeem on that day, equity of redemption still subsists. Equity says you can come in and redeem at any time. And why is it so? The mortgagees always do so many unfair things. They will clog or fester the equity of redemption. They may postpone the redemption for a longer date or render the redemption very illusory by creating all sorts of obstacles in the way. One of them is to say that even when you are ready to pay, they will tell you, no, we ask you to come and pay in 1 year. You cannot pay the money in full now, wait until next year. In the eyes of common law, it's a contract. That's what the contract says. But equity says no. You cannot clog the equity of redemption. You cannot postpone the period of redemption. Postponement of date of redemption is not allowed. An equitable mortgagee has the right to redeem his property. And I want you to take a look at so many cases that are cited for you, which will illustrate this principle. See the case of Samuel against Jara Timber and Wood Paving Corporation Limited, 1904. The case of Reeve against Leslie, Fairclough against Swansbury Company Limited, Nice Brick Estate Trust Limited against Bryan. These are classical cases upon which modern cases develop on principle of clogging of equity of redemption or the postponement of right of redemption, which are unconscious, which are inequitable, which are unfair and detrimental to the interests of the mortgagor. The reason is very clear. The mortgagee did not want the mortgagor to redeem his property. So they devised all sorts of strategies, either to render it illusory. For instance, they say if you don't pay within 6 months, you have lost. Don't bother to come back again. Or if you want to pay before that time, they will tell you, no, you cannot pay now. Wait until the time your 6 months. But maybe in 6 months, you may not have that money again. And so equity came in and said, no, it's a security transaction. You can pay at any time. Don't render it illusory. Neither should you clog the equity of redemption. It must be available. It is a right. Even if it has lost the legal date, if the date for legal redemption has passed, it should still be entitled to redeem the security. Another thing that the mortgagee normally do is to put what we call collateral advantage. Now, what do you mean by collateral advantage? If you borrow money from a bank, now they can tell you that if you want to insure the property, you have to go and insure it in our own company. That one will put more cost on your money. Or they will tell you that if you want to build bricks, go and buy the brick, the cement from their own company. Put onerous covenants that have nothing to do with the borrowing terms. Those terms of collateral advantages are, in the eyes of equity, are not acceptable. And any clause that is found like that will be struck down. Example of those clauses you find in cases like Biggs against Ordinate, Knox Company against Rice, Krelinga against New Patagonian Meat and Cold Storage Limited, and also in the modern cases of Esso Petroleum Limited against Upper Garage, 1968 appeal cases. I also note that the court will not declare mortgage terms void simply because they are unreasonable and more than unusually disadvantageous to the mortgagor. There must be unfair and unconscionable or morally reprehensible term of the whole mortgage itself. It's unfair, it's unconscionable, and it's unfair. So if you link an interest to the index, that is, if you have a flexible interest rate, or you tag it to the any rate that may be charged from time to time by the Central Bank of Nigeria, or any rate that may be charged by the London money market, those ones are not unfair because they can go up and down. The court will still uphold such terms. And I want you to see the case of City and Property Holding Limited against Dabra, more particularly Multi-Services Book Binding Limited against Madden. This particular one was a case in which the interest to be charged was linked to certain inflationary rates, and the court said it's not on unconscionable terms. That's not unusual in order to vary, to take into cognizance the vagaries of interest rate, to tie it down to the inflation index. And the court upheld the transaction that was not unconscionable. So, but where the court finds out that the terms are unfair, they are collateral advantages, or they are oppressive, or it clogs the equity of redemption, or fetters the right to redeem, as in all the cases that I've given you, the court will be willing and ready to strike out those terms, such that the mortgagee, the mortgagor will be able to retrieve his property or to redeem the property upon payment of the principal and interest, even after the legal right of redemption has passed. Do you have any questions for me? Class?
No, sir.
Sir, please, I have a question.
Go ahead.
But this does not apply when it is a legal mortgage. That's
It applies to all
like
the
redeeming
mortgages.
at any time. Oh, okay.
It applies to all mortgages. These are the rights of mortgagor, whether it is legal, whether it's equitable. The point I try to make, for maybe that you are getting confused, is the fact that I said that the influence of equity on law generally is mostly felt in the law of mortgages, because that is where equity plays significant role to protect the mortgagors against the mortgages. And how it does that, I gave you the background. The mortgages are Shylocks. They are ready to put in terms that will never allow you to redeem, or will clog your right of redemption, that are oppressive, that will make sure that you lose your property. And the court of common law, the common law judges will approve of it. But equity said, no, wait a minute. This thing is a mortgage, it's a security, it's not a sale. All these clauses you are putting into it, once they find it to be unfair, unquestionable, or oppressive, the court will strike it down and bring the thing back to. That is why, even when the foreclosure date has passed, the court will grant relief against forfeiture. That is why, if the legal date for redemption has passed, the court will be ready to say, do you have the money now? Pay. It may be passed at common law, but equity will still insist, collect your money, give the property back, because it is a mortgage. Is that clear?
Yes, sir. Thank you.
Any other question? I have 122 students participating. Any other question?
Sir.
Okay. We are moving small by small. Now, a mortgagee that is a mortgagor that is in possession has the right, once a mortgage is created, a mortgagee that is allowed to be in possession can also lease the property. He can also atone for the tenancy. In other words, a mortgagee in possession, a mortgagor in possession can also grant leases and accept surrender of leases. Because he's the one in possession, he can grant this lesser interest and do whatever he likes with the property. Do not forget that it is not a sale. It is a security arrangement. That is if the mortgagee permits him to be in possession. But if he doesn't permit him to be in possession, different rule will apply. But if he's allowed to be in possession, a mortgagee can continue to have possession of the property, create subsequent leases, also surrender leases to accept surrender of leases from the existing tenant. Now, what are the rights of the mortgagee? The rights of the mortgagees are many and they are cumulative. One, a mortgagee has so many powers, both granted by common law as well as by statutes. He has the right to take possession. He has the right to sell the property. He has the right to foreclose the property. He also has the right to appoint a receiver in order to ensure that he realizes his money and realizes his security and also recover his money. These rights are cumulative. We can exercise any of them at the same time, or he can decide to exercise them one after the other. So a mortgagee in the eyes of the law has what we call the bundle of rights, both personal and proprietary, which he can exercise for purposes of realizing his security and to recover the value of his money, that is both the principal and the interest. In other words, because they are cumulative, the exercise of one power does not prevent him from exercising the other. He may exercise it as and when or in a manner that is best suited to him. Now, the first right that a mortgagee has is the right to recover his debt. Whether a property is mortgage, is under a mortgage or not, once money is lent to someone, the mortgagee has a personal obligation to repay the loan. Even if the property is insufficient to meet it, he will cover the balance of the money to the mortgagee. So he who goes to go and borrow money must be prepared to pay for those things. So there's the express covenant by the mortgagor to repay the entire mortgage advance, accrued interest, and the cost, which will be invariably included in the mortgage contract. If the mortgagee sells the property and it discovers that the value of the property is not sufficient to meet the total indebtedness, he can still come back to sue the mortgagor for the shortfall. It's his right, because the security might not be sufficient enough to cover the value of the security might not be enough to cover the value of the money lent. So Security is just one side. You sell the land or property or anything, whatever the balance, if there's a shortfall, you pursue the mortgagor to come and pay the balance of the money. But an action for the recovery of a loan based on this thing can only be brought within 6 years if it is for the interest. Mortgage principal, 12 years. If you don't bring it within that period of time, you will lose your rights. I want you to take a look at the limitation law of Lagos State, section 21, Bristol and West PLC against Bale. There are many Nigerian cases. I think I should add more to it. Now, the right to take possession. If you remember when I started this lecture with you, I said that at common law, a mortgage is created by conveyance. Once you convey your totality of interest to the mortgagee, you have given him both ownership and possession at the same time. So a legal mortgagee has the legal right to take possession as soon as the ink is dry. That is, as soon as the mortgage transaction is signed by the parties, he can ask the mortgagor to vacate the property and move it. That's what the law provides. And so it doesn't need the mortgagor's consent. If he allows the mortgagor to stay, he's just giving it to him on a mercy. And the authority for that is the case of Landmade Limited against Dudley Marshall Properties Limited, 1957, Chancery at page 317, particularly at page 320. Our Nigerian position of that is what you find in Aujubagbe Light Industry against Chinekwe, where the court stated very clearly that a mortgagee may go into possession before the ink is dry on the mortgage, unless there is something in the contract, express or by application, whereby the mortgagor has constructed himself out of that right. So, if you borrow money to somebody and you don't want him to exercise possession over it, the mortgagee can move in immediately. But in practice, they don't, because it has some implications. If you move in, you have the duty to account for the rent that you have collected. So prudent mortgagees don't go into possession. Again, if it is a residential property, you cannot use force to recover possession. You have to go through the process of law, which is recovery process. Serve the necessary notices. They must have taught you that in leases. Because under the rule in Ojukwu against Governor of Lagos State, self-help and self-remedy is frowned against. The next power that a mortgagee has, both legal, that a legal mortgagee has, is power of sale. The power of sale is provided for both at common law and also in statutes. The most potent power that a mortgagee has is the power to sell. He can sell that property upon default. Once the mortgagor fails to pay the principal or to pay the interest, and at the agreed date, the mortgagee can exercise his power of sale. A legal mortgagee has a statutory power to sell. If you look at section 120, 1 of the PCL, section 35 of the Lagos State Mortgage Law, and section 19(1) of the Conveyancing Act, 1881, and the case of Pains against Radif or Aujubagbe Light Industry, the court stated clearly that a legal mortgagee has the right to sell, but upon two events must occur. The legal date for redemption must have passed, and the power of sale must have become exercisable. The power of sale must have arisen. It will arise when there is a default. That is, when the contractual date for payment has lapsed and the debtor has not paid, the mortgagor has not paid of his loan, either principal or interest, that in the eyes of the law, the power of sale has arisen. Yes, it has arisen, but you must satisfy the second condition. The power of sale must have been exercisable. It will become exercisable if these three conditions are cumulatively met. 1, you must serve a notice requiring payment of the mortgage debt, which you must serve on the mortgagee, and the mortgagee must have defaulted all or part of it for 3 months after the service of the notice. 2, if the mortgagee is in arrears of interest for 2 months, or 3, if the mortgagee is in breach of the provisions of the mortgage terms and you have already served him notice, which imposes an obligation upon the mortgagor. If it's in breach of any provision, then if those 3 conditions are satisfied, the legal mortgagee can sell. Section 123 PCL, Section 19, and Section 37 of the Mortgage Law of Lagos State. If the power of sale has arisen and it has been exercised or is exercisable, upon the sale of the property, that is the end. The mortgagor has no more power, even if it has arisen but not exercisable, and the man went ahead to sell. The interest is extinguished. The right of the mortgagor is only in damages against the company and not the right to the property any longer. That we find in Section 126 of the PCL, Section 20 of the Conveyancing Act, at Section 125 PCL, Section 38, subsection 2. If the power of sale has arisen before the mortgagee sells the property, the sale has not arisen. The sale is void, as there is no statutory power to sell. But if there had been a transfer to the third party, who is a bona fide purchaser for value, that is the end. But if the property, the power has arisen, but it has not become exercisable, the sale is valid and destroy the mortgagor equities of redemption. Section 126 of the PCL, as well as Section 20 Conveyancing Act and Section 38 subsection 2 of the Mortgage Law. The next question is there any duty that the potential mortgagee owes? A mortgagee under... Now, let me tell you something. An equitable mortgagee cannot sell. An equitable mortgagee can only sell with the approval of the court. Whereas a legal mortgagee has the inherent contractual and statutory power to sell without necessarily invoking the powers of the court. A legal mortgagee can sell without recourse if those 2 conditions are being satisfied, whereas an equitable mortgagee cannot sell unless he has the sanction of the court. I want you to go and look for my article that I wrote on the case in the duty of mortgagee when exercising power of sale. The article is written in 2002, volume 22, Journal of Private and Property Law, from page 97 to 112. You'll find that article very useful, and I want you to read it. You can also read my write-up in Balancing the Interests of Mortgagor and Mortgagees in the Recovery of Mortgage Loan under the Lagos State Mortgage Law 2010. Go and read it. You will find one or two things. If you can see Professor Omotolan's article too, Mortgagees Power of Sale, Hammer or Illusion. Those are classical articles that can illuminate your knowledge more and more on the mortgagees power exercise of power of sale. Now, a mortgagee that is exercising his powers of sale is under a general equitable duty to act in good faith towards the mortgagor in exercise of his power. In other words, yes, your power of sale has arisen, it has become exercisable. There are certain things you must not do which may render the sale void. You must act in good faith. You must not be fraudulent. And so if you do certain things that show some element of fraud or element of collusion or selling of property to yourself, the court will set aside such sales. And so a sale of property to oneself is not allowed. The sale must be genuine. I want you to see the case of Biatoni and Odutayo, Nigerian Loan Mortgage Company Limited against Ajit Mobi, which are the principal, and also the case of Hudson and Dean, the locus classicus case on the sale of property to oneself or to one cronies. Again, the duty of a mortgagee to exercise good faith does not mean you are supposed to take to go and take the best market value obtainable. It's not a duty of care as you find it in negligence, because Lord Denny was trying to bring in the principle of negligence into the mortgage law, but that was not allowed. In Coxmere Bricks Limited against Mutual Finance, Lord Denny introduced the doctrine of negligence, duty of care. But in the case of Park against Mortgage Services Funding Limited and Downsville Nominee Limited against First City Company Limited, the House of Lords, which consists of the property people, said, no, you cannot introduce the concept of tort into the law of property. It will not work because you cannot fetter the right of the mortgagee to sell the property. Only the duty that is imposed on the mortgagee is to exercise the duty of good faith. And that's why I encourage you to go and read that my article that I wrote on the duty of mortgagee when exercising power of sale. You will see the analysis there. Although the mortgagee is a trustee of the proceeds of the sale, that is, he has a duty to account. He must sell at a good market price, but he can choose the time to sell or the price in which he's going to sell. The mortgagee is not strictly speaking a trustee for the power of sale of the mortgagor. After all, the main reason to sell is for him to protect his own property, and those protections are for his own benefit. Nevertheless, while the mortgagee may sell at a time that suits him best and prefer his own interest to those of the mortgagor, if they conflict, he must take reasonable care to get the true market price for the mortgage property whenever it does sell. A mortgagee can sell at any time. He can decide to sell even when the price was low. But the most important thing, he cannot sell below the market value price. That will touch on his fairness. That will touch on his conscience. And the Court of Equity and Law will not accept that. I want you to take a look at the case of Park against Mortgage Services Funding Limited and Downsville Nominees Limited against First City Limited. First City Corporation Limited. and read my article in that area, it will make the whole thing more clearer. A mortgagee also have the power to appoint a receiver. A receiver is an agent appointed by court or by the mortgagee to collect the security and then exercise the power of the mortgagee for purposes of recovery of the loan. In that case, once a receiver is appointed, he can collect all those things. He will take possession of it. He will be responsible for managing and preserving the property, collecting income, running the business, paying all overheads and all other repairs. And he may also bring, if it's a company, he can revive the company back to pay the debt and also return the company back to them. But if he's unable to do so, then he can run the company and appoint a liquidator. So in most cases, if the mortgagee does not want to get involved with the management of realization of debt, he will appoint a receiver. And that is also provided for in law. Take a look at section 101, subsection 1, and 109, subsection 1 of the PCL. You also see the same provision in Lagos State mortgage law. It also provides for the appointment of receivers. Finally, do not forget, only a legal mortgage can appoint a receiver because it is statutory, it is also contractual. Only a legal mortgagee can sell because it is statutory, it is also contractual. An equitable mortgagee cannot sell without the powers of the court. The only remedy that an equitable mortgagee has, which is also available to a legal mortgagee, is foreclosure. That is the only remedy that an equitable mortgagee has, foreclosure. And that foreclosure can only also be done by getting another from the court. A foreclosure is tantamount to confiscation of the mortgage property. It is the extinguishment of the mortgagor's interest in the mortgage property to the benefit of the mortgagee. In other words, it is a judicial process by which the court grants the legal and beneficial interest in the mortgage property in favor of the mortgagee, thereby extinguishing the totality of interest previously held by the mortgagor in favor of the mortgagee. Really, the reason, even though it's the best way, it's a good way, in most cases, the mortgagor will go back to court asking for relief against forfeiture. And because it is a court of equity, and because in the hands of equity, a mortgage is seen as a security not being a sale, if a mortgagor seeks for relief against forfeiture, the court is always willing to accept. And what are the reliefs against forfeiture? A mortgagee who is unable to pay the full debt can say, yes, you want to foreclose, yeah, or you are foreclosed. Now I have my money, I will pay half. I will continue to pay the rest in the next 36 months. The court will reopen the foreclosure and say, okay, take. That is why banks don't, or creditors don't go for for forfeiture, because there is always an opportunity for the mortgagor to go back and seek relief against forfeiture. The right to seek for forfeiture is in the statute books. If you take a look at PCL, it's also there, relief against forfeiture, and see also the case of Pact Against Mortgage Services Funding Limited. On that note, I'm done with mortgages. You can ask your questions, and then I'm ready for questions if you are ready for me. I can see 30 chats. Hope it's not question. Any question? I hope I'm not just talking to myself.
So I have a question.
Go ahead.
Based on the right of a mortgagee to that's power of sale. So if a mortgagor now has a right to redeem that power of sale, the only thing like it has, how does that balance his mortgagee's right, the mortgagor's right to redeem when a mortgagee has power of sale?
Thank you very much. Don't forget that the mortgagor is a borrower. Don't forget that the mortgagee is the lender. Nobody will go and borrow money from somebody and you disturb his right to realize his investment. So the law tends to balance the two. A mortgagor has the right to redeem on the contractual date or thereafter. It is not a right that you hold forever. If you don't exercise that right before the mortgagee decides to sell and he sells, if it's a legal mortgagee, it's gone. Both your equity of redemption and your right of redemption, once that has gone, everything is extinguished. Don't forget it's a debt. You are unable to pay, and the man can sell your security in order to realize this. So the law tends to balance the two. The right of the mortgagor to borrow and the right of the mortgagee to sell if you don't pay. So go and read that my article, Balancing the Interests of the Mortgagee and Mortgagor under the Lagos State Mortgage Law. It's almost, so you will see my views there. To reschedule, Laura, I can see your hands up. You can ask your question.
Yes,
Thank
sir,
you,
please.
sir.
Sir, in equitable mortgage, I want to know, since there is no conveyancing, can the mortgagee exercise their right to possession?
Possession is don't forget that where we have equitable mortgagee by deposit of title, you have not really exercised, you have not really created a legal mortgage. It's only in the eyes of the law that they said we have created this thing. In practice, mortgagee don't usually take possession until when they are ready to sell, either through the appointment of receiver, or they go directly into possession. Only a legal mortgagee has immediate right of possession. Equitable mortgagee is already in possession. He has not even transferred a legal interest to you. Where is he going to get the possession? The equitable mortgagee, the mortgagor is in possession.
Okay, all right.
Are you clear now?
Yes, sir. Thank you, sir.
You're welcome. Do I still see any other hands or anybody that is interested in asking questions so that any other question?
Yes, sir.
I
Good
can see
afternoon, sir.
one M. Who is M?
Good afternoon, sir.
Yeah, go ahead. Good afternoon.
I just want to get a clarity. You said you are done with mortgages, like the topic
Yes.
in entirety, or just the scope of this class?
No, that's the equity in entirety.
Oh, okay.
That's mortgage. So you go back to them to say that Prof has finished his own side of his contract. I've
All
finished
right, sir.
mortgages, and that's my class for this session.
Thank you, sir.
You're welcome.
Sir, please, I have a question.
Go ahead.
So when the mortgagee wants to practice their rights or power to sue, do they send out like notice for like the pending sale?
Now, there are two ways to do it. Once there's a legal date of redemption, you must make a demand for your money if the power of sale has arisen. For you to exercise sale, say, come, you have not paid my money. If you don't pay within so period of time, I will exercise my power of sale. You don't need to do more than that. Now, there are ways of selling. You can sell by private treaty. That is, calling people privately to say, you see that property, the person is owing me. Can you pay this amount of money? And you sell the property to you. Or you can go by public auction, where people will come and bid for the property and then they will buy. Then that give notice to the mortgagee that you are selling. But in practice, both methods are used. But the one that banks prefers most is private sale. They don't need to go through auction. They sell the thing privately because it's contractual. The breach of it gives them the contractual right to sell.
Thank you, sir.
Good, you're welcome. Any other question from the class? Do you people understand I can see Collins. Collins, you have the floor. Collins.
Good afternoon, sir.
Good afternoon, Collins. How are you?
Fine, sir. So when a receiver is appointed over a mortgage property, to whom is the receiver accountable for the profits derived from the property, sir?
Profit. You cannot profit that of it. You have to sell the property and you have a duty to account both to the mortgagor and to the mortgagee. Because if they find out that they will oversell, and if I'm owing you 150 million naira now, you sold my property for 200 million, you have to return my 50 million back to me. You can't go away with the 50 million. That would be unconscionable. That would be fraud. So that is why the mortgagee too also follows what happens when the sale is. A mortgagee also follows when his property is subject of sale. Do you hear me?
Yes, sir. Thank you, sir.
You're welcome. Final question. This is 235. Well, if there is no questions for me, we draw the curtain for today. I wish you best of luck in your exam. Good afternoon.